Meta's CEO Mark Zuckerberg took the stand again yesterday, this in the federal antitrust trial against the social network giant. Joining us right now is Chris Kelly. He's the former Facebook chief privacy officer and general counsel and the founder of Kelly Investments. Good morning to you. Lots of different things that have emerged from this case. We talked about a couple of them on the way out of the break before we were teasing you. One of which, by the way, has nothing to do with the case itself, I guess, but is what the Wall Street Journal wrote about this morning, this idea that Mark Zuckerberg tried to settle this case for about $450 million, obviously not the $30 billion the FTC had been looking for, hoping to get closer to the Trump administration. I'm curious, did you get a chance to read that article? Because I think there's a lot of people looking at that, trying to understand what's really going on inside Metaland.
I did take a look at it, and it's actually pretty standard for there to be a lot of dialogue about the way that these cases settle. So I wasn't surprised by that conversation or the numbers, actually, to be frank.
In terms, though, of the transformation of both Meta and the political calculus around what's going on, can you speak to that? I think there's a question mark. By the way, there's a question mark among Republicans as to whether it's been a genuine move or a disingenuous move to get closer to this administration and to sort of tilt right, if you will, around some of the things that Mark's been involved in.
I've spoken before on this program about how the shift to free speech and discussion of, sort of working within the American free speech tradition is much more, I think, genuine than it's been portrayed as. It was put out there as something, some sort of sucking up to the administration. I do think that from the very beginnings, I mean, when I helped write the first content policies, we were always trying to make sure that people could have a wide range of free expression on the platform, and we didn't want to discriminate against people based on viewpoint in any way, shape, or form. So I think in a lot of ways this was a return to that. Obviously, I think that when a new administration comes in, you want to make sure that you have good relationships and that you're in constant dialogue about what's going on in the process. And so, again, like the story that I saw in the Wall Street Journal this morning and the fact that there have been these discussions over time is not rare at all. It's certainly quite common in these cases where you've either been talking to the commission or other people in the administration about how to resolve a case and try to suss out what's legitimate in terms of the concerns about protecting competition and what's about an overreach or an overread of antitrust law in the way that it might be applied. One of the most important things to note about the case that's being tried right now, I mean, Judge Bosberg, who is the fact finder in this case too, dismissed the case when it was first pled by the FTC, right. And they had to file an amended complaint to explain what the actual monopolization is. In antitrust cases, market definition is everything, and the market that they're trying to get here to describe here is incredibly narrow, doesn't include TikTok, doesn't include YouTube, doesn't include iMessage. So they've got an uphill battle, the FTC does in this case.
Well, my question to you is, given that there seems to have been these settlement talks prior, what do you think the chances are? How would you handicap the prospect that at some point during this trial, perhaps it even settles before there is a judgment? Or do you think at this point it's green lights ahead to the end? People are sort of
pot committed at this point if they have to go forward. I do think that there will be some rulings, interim rulings that will probably give the FTC a read as to how strongly their case is being perceived or how weakly their case is being perceived. And that will, of course, affect the way that negotiations go around settlement. I don't think that the company has any inclination to settle on the structural remedies that the FTC is asking for, the divestiture of Instagram, the divestiture of WhatsApp. I just don't think that there's any realistic possibility of the company settling for that. And I think it's pretty unlikely that the judge will order that as well.
How damaging do you think some of these emails are? And some of them we've known about for quite some time, where there are conversations literally about buying these things, in part because they're worried about the competition. Do you think unto itself that that's damaging?
One of the interesting things that hasn't been presented, I think, as aggressively as I would expect it to be, is that there were pro-competitive reasons for a lot of these acquisitions too. There's worries about whether or not Facebook would be excluded from the App Store at Apple or excluded from the Play Store at Google, and you needed leverage of another great mobile app like Instagram or like WhatsApp in order to do that. The board decks on the acquisition of WhatsApp, and again, all of this happened well after I left the company, but the board decks on the acquisition of WhatsApp, portrayed as a defensive move and a pro-competitive move against Apple. So there's a whole bunch of a different lens through which to see a lot of this, which I think you'll probably see from the Facebook presentation when they get to put their case in chief on.
Why have we not heard that before?
I actually think that it's been there in quite a number of the conversations, and that the messaging from the company so far has focused on the fact that the FTC approved these mergers. There's for any large merger, of course, review by the FTC, and then decided that was a mistake 8 years later. That's been a lot of the messaging so far. But there were definitely pro-competitive reasons for positioning against Apple and Google for the company to take these actions.
Is there a fireworks moment that we should be looking for in this case? I mean, so far it hasn't happened, I don't think.
Yeah, I don't know about that. It's I think everyone, whenever there's a court case, everyone looks for the Perry Mason moment, that. And in antitrust cases, you don't often get one. I was around the Microsoft Netscape antitrust case when I was a private practice antitrust lawyer representing Netscape, and we had a few of those where there was talk about cutting off the air supply for Netscape from Microsoft executives, and there were some more dramatic emails than I think you've seen in this case so far. But in most cases, business disputes are business disputes. And you end up in a bit of a morass in any event.